Welcome to Judica County. I'm your host, Cassandra Nicholas, and I'm here with attorneys Taylor Scruggs-Smith and Kimberly Lott. We're all attorneys with Whitaker & Hamer, your law firm for life with offices across the state of North Carolina. Today, we want to touch on a family law topic, specifically regarding a simple divorce. We're going to do a little bit more of a deep dive on that. I don't practice this area of law at all, so I need your expertise. Can you tell me, if someone's coming to you regarding a divorce, what do they need to know?
So the big thing about divorce is that the statute says that you have to be living separate and apart for a year in order to even file for the divorce. Us attorneys like to say a year and a day because you don't want to file on day 365, you want to file on day 366.
That seems like a long time. Are people familiar with that, or is that a surprising fact to them?
I think that's a surprising fact because every state kind of has different requirements on how long you have to wait before filing. So a lot of people are shocked to hear the year, but I think that they're even more shocked to hear that you do have to actually be living separate and apart. You can't be living in the same house and like one person has the right wing, one person has the left wing. You're saying that's separate and apart. The court requires you to actually split. Like you have to be paying one wife is paying her rent, husband's paying his rent. You guys are not living together anymore. So that's like one big thing that always comes up in my consultations, in my initial conversations with people about divorce.
Is that, you're telling them that they need to live apart? And then how does someone even go about that?
Somebody's got to move out. Somebody has to move out because the other big thing of the statute is that you have to be living separate and apart for a year with one party, just one, so husband or wife, with the intent that it remains permanent. So you can't split up.
Rekindle.
Yeah, you can't rekindle the marriage. So you can't be split for 3 months, then go back to telling everybody you're married and you guys are working it out and it's all gonna be fine for 3 months, and then try to be like, okay, well, we've already been separated for 6 months, let's just add on the other 6. Court says it has to be continuous year. So if you're still telling everybody you're married and not separated, you know, somebody could dispute that you're not really separated.
Can anything be done during that year, like legally, or is it you're just waiting that year and figuring it out on your own?
So you can work out the property distribution and things with your children during that year and come to some agreements. But as far as getting legally divorced, there's no way to get legally divorced until you've been separated for that year and a day.
So it's day 366 and a client's coming in. What now?
So now they have to pay us, and then we have to file with the court. And this is another big area where sometimes people get a little confused. It's not, divorce paperwork is not you and your wife sign the same thing and say, okay, now we're divorced. A judge has to actually sign off on a divorce decree. So we have to file a complaint. We have to serve your spouse with that complaint. We have to wait 30 days for them to have a chance to respond. And then we go to court. If you're represented by an attorney, you don't have to attend because your attorney is your representation. But somebody has to go to court and tell the judge, yes, these are all the facts. We've been separated a year and a day. This is when we got married. This is how many kids. There's no pending matters, or there is pending matters. And then the judge signs off. So it's not just you and your spouse sign the same paper saying you're divorced. A judge has to sign off on it.
So after that 366 days, it's still going to be at least a month or two, or is that the typical timeline?
It is. Once somebody has filed for divorce, the other person has 30 days to respond to that filing. And then if they don't respond during that time, or even if they do respond, then we set the matter on with the courts. That usually takes a couple of weeks depending on what county we're in. And that's when we are able to get in front of the judge. So streamline, the shortest amount of time it's going to be is typically about 45 days. And I will speak to another misconception that people tend to have is that one of the parties can hold up the divorce. As Taylor mentioned, it's not both of you signing a paper. If you have met the legal criteria for divorce, then one person can file for it and get it, even if the other party does not want to be divorced.
And one thing I'll add is that COVID has obviously changed the world in a certain way. So things that used to take 45 days are now closer to 90. And that's just because of, the mail system moving slower a little bit. The courts are backed up from things that got pushed so far behind from last year. So a lot of counties still have a cap on how many divorces can be heard on a particular day, which means you may have to pick a different date further out just because the court is streamlining and trying to organize how many cases are getting heard in a day.
So it sounds like patience is key in this whole process.
Is always key.
This was incredibly helpful. I definitely learned more about family law and about divorces, and hopefully everyone else did too. We thank you for joining us on this episode of Judica County. If you find yourself in need of legal assistance with a divorce, please give us a call at 919-772-7000 or contact us on our website, wh.lawyer. Again, we're Whitaker and Hamer, your law firm for life.